Hi, I'm Rachel Spears. I'm the Executive Director of Pro Bono Partnership of Atlanta, and I'm going to try to answer in the next 60 minutes a question that I get asked a lot from organizations that have just started, just gotten their 501c3 status, and they say to me, what do I need to do to not mess this up? What do I need to do to stay in compliance with all the laws and regulations that govern 501c3 nonprofits? Before I talk about that, I'll tell you a little bit about Pro Bono Partnership of Atlanta. For those of you that don't know us, our mission is to provide free legal services to nonprofits. We do that by matching them with volunteer attorneys. The next page, page 3, talks about our eligibility requirements. Take a look at that. And if you're eligible and interested in our services, you can go on our website to find out how to apply. I will say, since a lot of you are startup organizations that have just gotten your 501c3 status, it may be premature for us to help you. What you can really benefit from us is by taking advantage of all the resources we provide to help educate you, help you do your homework to understand these laws and how they affect you. Once you're more established, have funding, have programs, then you can come to us for assistance, for direct legal assistance for your organization. On that website, we have great articles and recordings of past webcasts that you should take advantage of. We are able to provide these webcasts to you on a monthly basis free of charge because GeorgiaAdvocates.org, part of Georgia Legal Services Program, allows us to use their technology for free, which is great. I understand that some of you are still having technical issues watching these webcasts, so we have emailed to you, and we also have on the screen some troubleshooting tips for you to help with that. But if your computer doesn't have the bandwidth to watch this, it might be better to watch it as a recording. It'll be posted by next week, and you can go back and watch it, and usually your computer can handle that better that way. On page 4, I'm going to talk about the format of today's webcast. As I said, we have a lot to cover in 60 minutes. So rather than cover everything in detail, we're going to have to hit the high points. I will talk about the subjects we see come up over and over again, give you a little bit of information, and then we have links for you to articles and webcasts on our website so you can go get more detailed information. I encourage you to go back following this webcast and check those out. I'd ask you to reserve your questions for the end because we have a lot to cover. Go ahead and type them in once you think of them, but just know that we're not going to cover them until the end. So closer, a few minutes before, you want to make sure you get your questions in. Please keep your questions general. I can't provide legal advice to you today, so if it's too specific, I won't be able to answer it, but general questions on information, we'll try my best to help you with. One question I get asked a lot by startup organizations is about their board. How big should it be? What should they do? What are their duties? Starting with the size of the board, I would say it should be a minimum of 3. That's fine for a startup organization, but as you grow, you'll probably increase the size of your board. The key is that whatever the number is, a majority of the members should be unrelated by family or by business. You have to have an independent board of directors. I run into people who've started a nonprofit, they're the founder, and they call it their baby, and they think of themselves as the owner of this organization. You're not. You can't be. As a 501c3, the organization has to be for the public good, and the IRS ensures that it's done for the public good by requiring that there be an independent board of directors, not just one person in charge. If you get to the point of having the founder be a paid executive director or something, it's really important that you have enough independent board members that can vote to approve that. We'll talk about conflicts of interest later, but you have to make sure that a majority are unrelated. When you get started, if you just got your 501c3 status, you know that the IRS requires you to have articles of incorporation and bylaws. Your articles typically don't change much, but your bylaws should be a document that evolves. These are the rules of your organization, and as you grow and as you do more, you'll realize that there may be changes you need to make. Maybe the size of your board needs to increase. Maybe you need to have different, officers added, but you can do that. So keep those bylaws handy. Every board member should have a copy of the articles and bylaws. If you have a board book, that's something that should be included in there. And go back to them and review them from time to time to see if they need updating with respect to the bylaws. Next, the board needs to meet regularly. I would say for most organizations, it needs to be 4 times a year at a minimum. For startup organizations where you really have a working board, you're probably meeting more like monthly. But those meetings need to be productive. They shouldn't be just a rubber stamp of whatever the founder, executive director, or who's running the operations on a day-to-day basis is doing. Rather, the board should be provided with materials like financial kind of updates in advance. They should have the opportunity to ask questions and be encouraged to ask questions. We'll talk about their duties on the next slide, and as part of their duties, they need to be actively engaged getting information from those running the organization. We have a webcast on this topic I encourage you to watch. I want to briefly mention Georgia's sunshine laws. These are the open records and open meetings laws that generally apply to governmental agencies, but there are some nonprofits that are covered. Nonprofits that get tax money to run their operations and nonprofits that perform a governmental function. For example, the Piedmont Park Conservancy that runs Piedmont Park for the City of Atlanta is covered by the open records and open meetings laws. If you think you might be covered, you want to check our website. We've just made revisions to this article because the Georgia legislature just updated it. Check that out, see if you are covered, and if so, what you need to do with respect to keeping your meetings open to the public. By law, nonprofit board members have certain duties they must fulfill, primarily the duty of care and the duty of loyalty. The duty of care, I mentioned before, requires board members to do their job, not just be the name on the letterhead. Go to meetings, ask questions, read the materials they're provided, and not just be a rubber stamp. We have a webcast about questions board members should ask. I encourage you to get your board members to watch that, and frankly, maybe to watch this whole webcast to get a basic understanding. Duty of loyalty means that your board should be loyal to the organization above their own interest and maybe the interest of their business or their family. We will talk later about conflicts of interest, where you have a board member who maybe has a business that is doing business with the nonprofit, and you have to be very careful about those types of relationships. But above all else, the board member owes a duty to the organization to put the interest of the organization above their own. And we have another article that you can go back to for more information. Next, I want to talk about record keeping. I get a lot of questions about keeping minutes, and we have an article about that, but you need to be aware also that when as a 501c3, you have to fill out a Form 990 each year, and we'll talk a little bit about that later in the different versions of the form. But the long form asks, do you keep minutes? And contemporaneous minutes, which means they're basically done within 60 days of the meeting or before the next meeting. And it's a yes or no question. And you want to be able to say, yes, we keep minutes. That's something the IRS is going to expect of you. Other records you need to keep are employee records. If you are an employer, keep track of those and keep those separate from employee health records. Then your basic financial kind of accounting and tax records are something you want to make sure that you have. Contracts, especially important contracts, you want to keep handy. And there may be other documents as well. But another thing that the IRS asks you on the Form 990 is whether you have a document retention policy. And for organizations that are more established and are large enough to be filling out that long Form 990, it's a good idea to get a document retention policy. The most important thing that policy is going to say is that if the organization is under investigation, it will not destroy documents. That may seem like common sense to you, but there have been some bad actors out there that they put forth this rule that you're not allowed, a 501c3 cannot destroy documents if it's under investigation. But a good document retention policy will also put in there how long you keep various types of records for. I always like to bring up financial policies and procedures. An organization should have financial procedures that establish internal controls within the organization. What I mean by internal controls is that you divide up the duties when it comes to your money. There shouldn't be one person that does everything with the money, opens the mail to get the checks, delivers the checks to the bank, reads the bank statements, does the bookkeeping. If you have one person doing all of those things, you're setting yourself up to have employee theft or even mistakes made. So I really encourage organizations to divide up those duties. It can be difficult for a small organization like ours, frankly, to do this. So we divide up the duties to include our volunteer board treasurer and 2 staff members so that we can avoid the possibility of something happening to the money. And you may think that would never happen in our organization, but I can tell you it has happened in quite a few of our clients' organizations, and they are always shocked. So really encourage you to look at that and to take a look at our workshop, our webcast on financial policies. Next, I want to talk to you about insurance because I get asked all the time about insurance. I am not an insurance broker. I'm certainly not an expert on this, but I'll tell you what I tell everybody. Get a good insurance broker, preferably one that works with nonprofits. Tell them everything that you do. Be open with them and ask them to recommend to you what kind of insurance you need. And ask them to rank it because you're not going to be able to afford every kind of insurance they recommend to you. And remember, they are trying to sell you something. But they're probably going to recommend, number one, that you get some sort of a general liability policy to cover property and casualty. I think that's probably the most important thing you're going to need. And then depending on what types of things you do, there may be other types of policies you need as well. I get asked a lot about directors and officers liability insurance. That may be a good idea for your organization. It's certainly a best practice, but in reality, it's not something most startup nonprofits can afford. You may have a board that demands it, and that's something to consider, and you may need to get it. But I think a lot of people think directors and officers liability insurance covers more than it does. So understand what it does and does not cover. You can find out more about that with our webcast. For more information on corporate governance, we have some articles and webinars that you can watch here. Next, I want to turn to the 501c3 side of this with the IRS. You've gotten that 501c3 status. It probably is now and will continue to be your most important asset because it allows not only is your income not taxed by the IRS, but you are able to receive tax-deductible donations, which for a nonprofit can really be the lifeblood of the organization's funding is those tax-deductible donations from individuals. So now that you've got it, you want to make sure you keep it. When you were approved by the IRS for 501c3 status, they did it based on what you put in your Form 1023. You put in there your activities, what you plan to do, your planned budget. You need to update the IRS if those things change significantly because your 501c3 status is for you to do what you said you would do in the Form 1023. That doesn't mean you can go out and go in a totally new direction and still have that 501c3 status. So the 1023 is another form you want to keep on hand, refer back to, and be aware of what is in that document. As I said, you might need to update the IRS if things change, and if they change dramatically, you might have to apply for 501c3 status again. Another thing you want to make sure you do is have your board review the Form 990. That's something the IRS asks on the Form 990, whether you have the board review them in advance. And it's a really good idea to get the board as part of their basic duty to review that document before it's filed. As a 501c3, there are certain things that you can and cannot do. A very big one you cannot do is any sort of political activity. What I mean by that is anything to support or oppose a candidate for public office. We're in an election year, so it's always a good reminder that your organization cannot be involved in political campaigns. Now, I get the question a lot about whether individual staff people, the executive director, can get involved. And you as an individual can do that, but you have to be very careful that it is as yourself and not with any tie to the organization. So obviously don't wear your name tag or your t-shirt for your organization. Don't do it on company time. Don't use your fax machine to send something out. Be very careful about that. Lobbying is a different thing. Lobbying has to do with supporting or opposing legislation before the Congress or some legislative body. There is not a prohibition on lobbying. Nonprofits are allowed to do some of it, but it cannot be a substantial amount of the organization's activities. Those rules can be pretty confusing. There's not a bright line about what that percentage can or can't be. So if you're doing some lobbying, I really encourage you to take a look at our resources and maybe get some direct help from a lawyer with knowledge in this area to make sure that you're not doing more than is allowed. And there's also an option for organizations to file something called a 501H election. I won't get into that now, but these articles do, and we have a webcast coming up in August that covers this topic that I encourage you to watch the dates on the slide. I'm on page 12. I want to talk to you about unrelated business income. This is something I always dread bringing up because it's really hard to explain, especially in a short time, but let me try. I mentioned to you that as a 501c3, you do not have to pay tax to the IRS on your income, your business income. There's an exception to that. That is for income from a business that is unrelated to your mission. It's not enough that the income be a fundraiser for you to do your mission. If you have income from a trade or business that is not related to your mission, it might be taxable to the IRS. There are a lot of exceptions to this that can get you out of paying those taxes. So if you come up with some sort of a creative fundraising idea where you're selling something, bringing in income, you might want to have somebody help you guide you through these unrelated business income rules. You might find that you meet one of those exceptions and don't have to pay taxes, or you might find that you have to pay taxes, but you're still making enough to make it worth it. To try to give you some quick examples, if an organization opens a store to sell items and then the money goes back to that mission, that might be unrelated business income from that store. But as I mentioned, there are a lot of exceptions. You might be able to say it's related to your mission if your mission is to prepare people for jobs in retail, people that have been homeless, then maybe that store helps with your mission. Or if all of the goods are donated to the store, then there's an exception from that tax. Or if everybody that runs the store is volunteers, there's an exception. It's a complicated area. If you want to know more about it, please take a look at these resources on our website and get more information. The IRS does have some requirements for 501c3 organizations to publicly disclose their records. As a 501c3, you are required to show anyone who asked for it your 990 forms, your Form 1023, that application you filled out for tax-exempt status, and your IRS determination letter, your 501c3 letter. A lot of organizations, as a best practice, will post some or all of this on their website. But know that that information should be publicly available. Slide 14, I want to talk about donor acknowledgments. This is an area that's very important, but a lot of people are not aware of. You've all given money to a charity and you received a thank you letter in return. What you may not realize is the IRS has rules about what needs to be in that letter. And what needs to be in that letter depends on what the donation was, whether it was cash or cash equivalent, a check, credit card, whatever, or whether it was goods. And it also matters whether the donor received anything in exchange for the donation. So let me give you some examples. For a donation of cash or money of some type, you should thank the donor by thanking them for the donation of the specific amount they gave you, the date of the donation, and a statement in there saying that they received nothing in exchange for that donation, if that's the case. If it's a donation of goods, books, clothes, whatever you take to the Goodwill, then the acknowledgement should not include a value of the donation. It should just say what it was, a box of books, 30 sweaters, whatever it is, and then say, if it's true, nothing was given in exchange for that donation. The value of that donation, that's up to the taxpayer for them to decide what they want to declare as the value. You should not put that in there. For quid pro quo donations, and that's where the donor receives something in exchange, it can be a ticket to an event or a box of CDs, something like that. The organization is required to disclose the fair market value of what they received in exchange, because the value of their donation, the amount of their donation, is going to be deducted by the amount they received in exchange. So if someone pays $100 to your organization, in exchange they receive a ticket to your gala event, and the fair market value of the food and entertainment and gift basket that they received when they went to the gala event is $40, they're only going to be able to take a tax deduction for $60. By the way, we have all this on our website, so if you're not following that, you can go back and look at it. But the rules are really specific. You need to keep that in mind. Something else you should know is that donations of services are not deductible. So I encourage you to send a thank you note, but don't say that their donation of services is tax deductible in that acknowledgement. If you're accepting vehicle donations or donations of goods that are very expensive, there may be some appraisals you have to do, and there's some additional steps. So again, go to our website for more information. Here's another subject I hesitate to bring up because it can get really complicated, but you got to know it. The IRS has prohibitions against private benefit and private inurement for 501c3 organizations. Now, what is private inurement? Let's start with private benefit. As a 501c3 organization, you have to make sure that the activities of the organization benefit the public, and particularly benefit your mission. They should not benefit any individual or any for-profit corporation. Also, private inurement takes that a step further. They shouldn't benefit any insiders, so your board of directors, your founder, your executive staff, funders. The work of the organization should not improperly benefit them. And unfortunately, you see this from time to time. You see people taking advantage of their relationship to a 501c3 to make money for themselves. If an organization is found to be doing that, the individuals that benefited can be fined, the organization can be fined, and worst case scenario, the organization can lose its tax-exempt status. The best way to avoid this is a good conflict of interest policy, which I'll talk about on the next slide. But let me mention one example of private inurement, which is where an organization improperly benefits an insider. Executive compensation. Now, for most of you, this is the last thing you need to worry about because you don't have any money, so you can't pay anybody. Certainly can't pay them an unreasonable amount, but be aware of this. Some very large nonprofits have gotten in trouble for paying their executives too much money. And the IRS says you can absolutely pay your staff a reasonable salary, but it has to be comparable to what other organizations of a similar size in a similar area, pay people with a similar level of expertise. You're getting comp information here, and you have to make sure that you're in line with what other similar organizations are paying. We have more information about this in your article. Like I said, probably not a big concern for your organization, but just be aware as you grow, something to think about. Now, as I mentioned before, the IRS asks you things on your Form 990. One of them is whether you have a conflict of interest policy. They asked you this when you applied for 501c3 status. And it's almost a requirement, really, to get 501c3 status that you have a conflict of interest policy. But it should not be something that you file away and never look at again. It should be like your articles and bylaws in that board book. It should be something you pull out regularly, have available at meetings, because you're going to go back to this. Basically, a conflict of interest lays out, the policy lays out the procedures you should follow if there is a conflict of interest. What I mean by that is where the interest of an individual are not in line with the interest of the organization. So you have a board member who, for some reason, a lot of board members seem to own printing companies. You have a board member that owns a printing company. The nonprofit is looking to get their materials printed. And they say, oh, you have a printing company. That is a potential conflict of interest. The board member could benefit financially if the nonprofit uses their services. But it's not as simple as that. That doesn't mean that you can never use the services of your board member. You have to look deeper into that. And your conflict of interest policy is going to tell you basically disclose the potential conflict, make sure everybody's aware of that. This shouldn't be something that happens without people being aware of it. The board member with the conflict of interest needs to stay out of it, leave the room. The rest of the board should investigate and determine whether this transaction is in the best interest of the organization. Oftentimes your board is going to donate things, they're going to give you the best deal possible. But the board has to investigate and confirm this is a good printer, they do the type of work we need, and they're giving us a great deal because we've gotten quotes from other companies and they were much more expensive. If you go through all that, if the board votes and decides that is indeed in the best interest of the organization, and then you put that in your minutes, you're good. You followed the policy and you can proceed. But you've got to make sure you follow that policy every time something like that comes up. Every time the organization hires, a relative of a board member or the executive director, something like that, pull out that conflict of interest policy. We have a great webcast on this from last month that I encourage you to watch as well. Slide 17 is a compliance guide from the IRS that you can check out for more information. All right, a common misconception from 501c3 organizations is that because they are a tax-exempt organization, they don't have to pay taxes. That is not true. 501c3 organizations do not have to pay taxes on their business income to the IRS. That's all that means. But think about in your everyday life how many different kinds of taxes you pay. It's true of a nonprofit as well. There are lots of different types of taxes, and we have to kind of walk through each one of those and determine whether or not there is some exemption. Before we get to that, I want to go through, let me say one big exception to what I just said about you don't have to pay income to the IRS on your business income is that exception we talked about for if it's unrelated to your mission. But let me mention annual filings. I've talked a few times about the Form 990. For those of you that are not familiar with it, every 501c3 organization has to file every year some version of the Form 990. There are 3 versions, and which version you file depends on primarily the amount of revenue you bring in, but also the amount of assets you have. The Form 990 is the long form that asks all these questions I've been mentioning. The Form 990 EZ is a little bit shorter, and the Form 990N is extremely short. They call it an e-postcard because it's about the size of a postcard, and you file it electronically. For some reason, these 3 sizes always make me think of Goldilocks and the 3 Bears. But anyway, you need to look at the requirements, which one you need to file. They've lowered the thresholds enough that a lot of organizations are filling out that Form 990 for the first time. And for those of you, and it's at $200,000. So if your revenue is $200,000 or more, you have to fill out the Form 990. If you are there, don't wait until it's due to look at that. It asks you all these questions about whether you have a record retention policy, a whistleblower policy, whether you keep minutes. You can go ahead and fix that now so that next year when you're doing the Form 990, you can answer the way you want to answer. So take a look at those sooner rather than later. There's another filing you have to fill out if you have unrelated business income. That's the Form 990T. One thing you should know is if you don't file the proper version of these, if you don't file a Form 990 for 3 years running, the IRS will take away your tax-exempt status. That's new as of last year. Thousands, I think hundreds of thousands of organizations lost their tax-exempt status last year for failure to file. So keep up with that. That's your responsibility. Georgia has some separate filing requirements for 501c3 organizations. The 501c3 status gives you an exemption from paying taxes on your business income to the IRS. But what about the state of Georgia? In order to get exempt in the state of Georgia, when you send your 990 in to the IRS that first time, you need to send it to the state of Georgia as well. And along with that, you need to send your articles of incorporation, I think your 501c3 letter. There's an article you can refer to about exactly what you need to do. And every year after that, when you send in your 990 to the IRS or 990EZ or N, and if you're doing the 990T, you also have to send that to the state of Georgia. And if you have unrelated business income, you need to send a Form 600T to the state of Georgia because you're going to owe taxes to the state on that as well. Next, I want to talk about payroll taxes. If there's an area where you can really get in trouble, this is it. So when you get to a point where you are paying people, make sure you are taking out payroll taxes where required. Federal payroll taxes include Medicare and Social Security. A 501c3 has to pay those just like any employer. Georgia also has payroll taxes you will have to pay. There's also unemployment taxes. I will discuss the state unemployment taxes at length later, but when it comes to federal unemployment taxes or FUTA, you do get lucky here. 501c3s are exempt from the federal unemployment tax. I encourage all organizations that have even one paid employee to get a payroll service. If you mess this up, you're going to be dealing with IRS for years. So I think it's a good investment to get somebody who knows what they're doing to help you with your payroll. Sales and use tax is another big surprise for nonprofits. I run into a lot of people that assume as a 501c3 they do not have to pay sales tax when they go buy snacks at Walmart, and they don't have to collect sales tax when they are selling items, such as when they have a silent auction. In truth, in Georgia, most 501c3 nonprofits have to pay and collect sales tax. There are a few very specific exceptions, such as hospices, child placement agencies, some healthcare-related activities, but the exceptions are very specific. So you need to go and look. If you think you're exempt, go look it up, see if you meet one of those exemptions. If so, you have to file and get that exemption from the Department of Revenue. Otherwise, you're paying it and you are collecting it. And we have information on our website about how to do that. And soon we'll have an article that goes into more detail on those exemptions. But you can start with what we have there now about sales tax. When it comes to real property, if the organization is fortunate enough to own real property, you may be eligible for property tax exemptions, but you have to apply with the tax assessor, and it's not automatic. Just because you're a 501c3 doesn't mean that any real property you own is exempt from property taxes. So we have a webcast on this topic you can look to for more detail. Same with personal property. Businesses have to pay tax on equipment that they own, and nonprofits can get exemption on that, but they have to apply for it. Your accountant can help walk you through that. We have on page 21 a link to an article that covers a lot of this for you. All right, do we have separate filings with the state? And not surprisingly, the answer is yes. First of all is your annual corporate registration. When you file to become a nonprofit, you filed with the Secretary of State's office. Every year by April 1st, you have to update with your annual corporate filing, update who your board officers are and your contact information, and there's a fee associated with that. If you don't do that for, I think, 3 years, your organization will be administratively dissolved. It won't exist as a corporation. So I encourage you to go check the Secretary of State's website, search your own organization, and find out if you're in compliance and get in compliance if you're not. And keep up with that, set a reminder for yourself, because just because you didn't get their reminder doesn't mean you don't have to do it. If you are doing business in other states, you might have to register as a foreign corporation in those states. Foreign doesn't mean from another country. In this context, it means from another state. So if you have operations in Alabama or South Carolina, you might need to register there as well. Every state's rules on this are different, so you should look at their Secretary of State's website and get more information. If your organization is operating under a name that is different from the one you registered to get your corporate status and your 501c3 status, then you're going to need to register that trade name or DBA, doing business as name, with the clerk of the court of your county. And we have an article for more information on that. Next, business licenses. I get asked this question, whether nonprofits need business licenses. And generally they do. Just like any business, a nonprofit is required to have a business license from the county. But unlike for-profit businesses, that doesn't mean they have to pay tax. And probably don't have to pay the filing fee either, but they do need to register for that, and we have some more information on that. I'm on page 23. Charitable solicitation registration seems to be a step that a lot of organizations miss. It's confusing because it is a filing with the Secretary of State's office, just like your corporate annual filing, but this is something different. It's a filing required of any organization that is soliciting money from the general public. So if you're out there asking for money, and I don't know of many 501c3s that are not, you need to register with the Secretary of State's office. There are a few exceptions, one of which is if you make less than $25,000 each year. But it may be a good idea to go ahead and register anyway, because once you get to that point, you might forget to register. There's a Form C-100 you have to fill out. They ask pretty personal information about your board members, your board officers, because they want to check up on you. It's sort of the idea is that if you're collecting money from the general public, they want to make sure you're not using it to go to Hawaii next week. So fill out that information. You'll need to renew it every 2 years. And you can check the website to see if you're registered, and if not, go ahead and get in compliance. If you are soliciting money from other states, you might have to file in those states as well. Just about every state has some sort of charitable solicitation registration requirement. And the level of fundraising in each state that leads you to have to file varies. It's a confusing area. For most startup organizations, your money is really just coming from here in Georgia, and it's not an issue. But if you are an organization that gets donations from across the country, you might want to look into the multi-state filing, which can accomplish, I think, filing with 33 states at once, and get some help to determine whether you need to file in more places. And we've got a webinar and some more information on that topic. Okay, I always like to cover raffles, because people seem to be so surprised by this. But in Georgia, gambling is illegal. That's no surprise. And gambling is defined as any activity where you pay to participate, where it's a game of chance, not a game of skill. You know, you pull your name out of a hat sort of thing, and where you get a prize. That's gambling. So raffles, door prizes, bingo, they're all gambling. In Georgia, gambling is generally illegal, but there is an exception for 501c3s where they can conduct raffles and bingo under certain kind of requirements, but they have to first get a raffle license from the Sheriff's Department. The license is about $100, and you have to do it every year. And if you don't do it, it is a crime in the state of Georgia. It's illegal. So get in compliance with that. I know that a lot of people are doing this improperly, but I want you to be aware of what the law is. We have a link there to more information on filings that you can check out. All right. At some point, hopefully you will have the money to hire somebody, to pay somebody. And by the way, I'm talking about giving anyone money to work for your organization. You may not think of them as an employee, but if you're giving someone a stipend or, money at the holidays or something, you might inadvertently be making them an employee for your organization. So first, be very careful about giving people money to work for you, if you call them interns or volunteers or whatever, because you may be making them an employee. But when it comes to employees, as you can imagine, there are a lot of legal issues that come up with hiring and firing people. So we have a whole webcast on the topic. There are rules about what you can ask in an interview and certainly considerations you want to make if you are terminating someone. So I encourage you to check that out. When it comes to hiring, and this can be when it comes to hiring an employee or choosing your volunteers, a lot of organizations really need to think about background screening, particularly if your organization works with children, the elderly, the disabled, other vulnerable populations. You're probably going to want to be extremely careful about the people that are working one-on-one with those populations. So criminal background checks, checking their references, other things are going to be really important. We have quite a few articles on this topic that I encourage you to check out, and some resources for how you can get background checks. I have a webcast on here also on immigration law. We have a lot of clients that work with refugee and immigrant populations. Some of their employees are refugees and immigrants, and you need to be familiar with what the laws are when it comes to that. Things like getting visas. All right. I mentioned earlier that one area that I see nonprofits get into trouble with most is payroll taxes. Included in that is when nonprofits don't take out payroll taxes when they should. And the way they get into trouble with this is by treating people that they pay as contractors rather than employees. You do not get to choose inadvertently to make somebody a contractor rather than employee. See a lot of nonprofits that do this in order to get around paying payroll taxes and see it as a cost savings. The IRS lays out rules about who's an employee and who's a contractor. They have a 21-point factor test that you look at to determine whether somebody is truly a contractor. But you should know that they consider most everyone an employee. And they want people to be employees because they want their payroll taxes taken out. It's a lot less likely they're going to get the money if you treat the person as a contractor. So if you have someone that you want to treat as a contractor or are treating as a contractor, you really need to make sure that they fit what is considered a contractor by the IRS. Basically what it comes down to is control in the relationship. A contractor has much more control than an employee. And some of those factors that they look at include who sets the hours? Does the employer set the hours? Does the employer provide the supplies, the equipment necessary? Does the employer train the individual, tell them how things are done? Or is that all up to the contractor, and the contractor does it on their own time with their own resources and just gets the project done? That's only a few of the factors. You really have to look at all of them. But generally speaking, most of your workers are going to be employees, so be very careful in using contractors. We have a lot of information on this on our website. You can also go to stayexempt.org, which is one of the links we have at the end, which is an IRS website that gives you more information. Another thing you need to think about when you have people working for you. We talked first about determining whether they're contractors or employees. Once you determine that someone's an employee, you have to determine whether they're exempt or non-exempt. What this comes down to basically is whether you pay them overtime or not. A lot of people confuse this thinking that, oh, that's salaried or hourly. If you're salaried, you don't get overtime. If you're hourly, you do. It's not as simple as that. There are a lot of nonprofit employees who are salaried but who are eligible for overtime. And if it's someone who's eligible for overtime, the organization has to pay them time and a half for every hour worked over 40 hours in a work week. And most of your employees are going to be eligible for overtime. There are very few exceptions that it basically comes down to a few categories you have to fit into in order to be exempt. I can't cover all of this right now, so I refer you to resources on our website. But when you have employees, you want to make sure you know who's exempt, who's non-exempt, and make sure you're having those that are eligible for overtime. Keep track of their time so you can make sure, number one, you're paying them overtime, but number two, you're paying them a minimum wage. There are also issues about how you pay your workers. when you pay your workers. So please check out these resources. I also have a link here to a webcast we did on employee evaluations that may be helpful for you. And I also want to discuss workers' compensation. We have updated this article, so in the next week there will be a new link. We'll try to get that new link in the recording, in the version we put up with the recording. But what you need to know about workers' compensation is that in Georgia, every employer is required to have workers' compensation insurance. By law, they have to have this insurance if they have 3 or more employees. What's tricky for nonprofits is employees in this context includes your board officers, your board chair, your vice chair, secretary, even if they're unpaid. So a nonprofit with fewer than 3 paid employees can still be subject to workers' comp laws if they have, and they do, officers. So this updated article is going to tell you a little bit more about that tricky side of this. But I encourage you to talk to an insurance broker about whether you need workers' compensation insurance, and if so, get it. You're required by law to do so, and it helps protect the organization. Other resources we have in employment laws cover employment discrimination laws. Most of you, as small employers, most of the discrimination laws will not apply to you, but you need to be aware of them. And obviously, you probably don't want to discriminate anyway. So take a look at this information and know what the risks are. Last thing, I want to talk about employer posting requirements. As an employer, you are required by law to have certain signs up that tell employees about their rights. We have them on a bulletin board in our office. And even as a small employer, a lot of these apply to you. So you can go on our website and check that out. Next, I want to talk about benefits. A lot of organizations ask me if they have to provide benefits like healthcare insurance to their employees. No, you do not have to provide those benefits. The important thing you need to know that is if you are providing it to someone, you have to provide it to everybody in that class of employees. So if you have one employee that you offer healthcare insurance to, you have to offer it to all your full-time employees. You can separate out, for example, part-time employees, but you just have to do it everybody in kind of the same class. There is a tax credit you might be eligible for providing health insurance. A lot of small nonprofits are, so check that out. And keep in mind with the healthcare law changes, a lot of this is going to change. But I believe even with that, there's going to be exceptions for small employers. If you offer health insurance, there are rules about continuing to offer that to employees after they leave the organization. You've heard of COBRA. COBRA only applies to very large organizations, but there are also state laws that apply to organizations that are smaller. So if you have somebody leave, there are certain steps you need to take with respect to their health insurance, and check out that article. If you need to terminate someone, as I mentioned, there's a lot of considerations you need to make. For our clients, I really encourage them to contact us before they let someone go so we can sort of walk them through it. But we do have some resources here. And I also mentioned here social media, simply because we have an article in here that tells you about some recent updates. You may be surprised to know that if you have an employee who goes on Facebook and complains about the organization and how much they're paid and the people they work with, you might assume that you can terminate that person. But there are rules coming out from the National Labor Relations Board that limit your ability to do so. And whether you have unionized employees or not, those rules apply to you. So be particularly careful if the reason you're terminating someone has to do with their social media activity. I'd really encourage you to talk to a lawyer. I told you I would get back to unemployment insurance. This is a complicated area and an area where I see a lot of nonprofits mess up. In Georgia, if you have basically 4 employees or more, you are covered by the unemployment insurance laws. If you have less than 4 employees, then you're probably not covered. As I mentioned, the law is a little more complicated than that, so check out the article. But basically, once you get to 4, you're going to be covered by unemployment insurance laws. You're going to have to register with the Department of Labor. And you're going to make the choice at that time whether you want to have unemployment taken out of your payroll or whether you want to choose the reimbursement option. It's an option only available to 501c3s. If you choose the reimbursement option, if you have a former employee file for unemployment, you have to pay the Department of Labor back for that unemployment. If you got it taken out in the first place, they already have the funds to pay the person. But which you decide is going to depend on the amount of turnover in your organization, whether you have a reserve fund that you can use to pay that unemployment insurance or not. But I encourage you to go and get more information about this. And keep it in mind, if you're small now and you have one employee, but a year from now you have 4, don't forget this, because at that point you're going to have to register with the Department of Labor. We also have some guidance in here on what you can do when you terminate somebody to put yourself in the best position when it comes to unemployment. Technically, they should not be eligible for unemployment if they were terminated for cause. But there are things you can do to really put yourself in the best position possible to make sure you're not paying unemployment if you shouldn't have to. All right. Volunteers. Yes, there are legal risks of working with volunteers. There's the possibility they could injure someone or they could get injured themselves. We have seen it happen quite a bit. The reality, of course, is that that doesn't mean you're not going to use volunteers. Nonprofits oftentimes exist solely because of the help of volunteers. So you just want to take steps to put the organization in the best position possible to mitigate those risks, to try to limit them. One thing you can do is to get waivers and releases from their volunteers saying that if they're injured in their volunteer activity, they will not sue the organization. We really encourage everyone to get these signed by their volunteers, and volunteers are used to signing these. I don't think people usually have a problem with that. We also have some resources about other steps you can take. This is an area where insurance is a good idea. Make sure your broker knows what you do with volunteers. You want to train your volunteers. You want to take steps to make sure you have safety kind of things in place to keep them safe. There's a lot you can do to limit those risks. Of course, you can't eliminate them altogether. All right, I'm going to talk about intellectual property and then start to wrap up. So let me go ahead and say, if you have any questions, please get them in now, and I will address them in a few minutes. I get a lot of questions about intellectual property. And people often don't know how to ask it. They just know that they have a name, a logo, curriculum, other things that are theirs, and they want to protect them. And there are a lot of rules about how you can protect your intellectual property. They basically fit into 3 buckets: trademark, copyright, patent. Trademark usually is people protecting their name, their logo, maybe the name of a fundraiser. Copyright comes into play, I see more with organizations that have a video or a book or curriculum of some sort they want to protect. Patent is usually something that has an invention. We don't do a lot of patent work, so I'm not going to talk about that. But trademarks, you should know that just by using the name of your organization, just by putting your logo out there, you have trademark rights. You can strengthen those trademark rights by registering a trademark with the state or with the U.S. Patent and Trademark Office. There are filing fees associated with that, so you need to figure out whether it's worth it to you, whether you gain enough to offset, the cost of those fees. But this is a good idea to look at whether trademark registration makes sense for you. Copyright, similarly, you have rights. Just by putting that out there, the video you did, you have certain copyright protections, but you can strengthen those by registering them with the Library of Congress. The fees are less when it comes to that. There's a lot that goes into intellectual property, which is why we have experts that advise nonprofits on this, not me. But we have resources on the next page that you can go to and learn more about this, including one on websites. Just about every nonprofit has a website, and you want to be careful about what you put on there, both to protect what you put on there, but also to make sure you're not infringing on other people's rights. If you take somebody's, picture from another website, take something they've written or put their logo on there, you want to make sure you have rights to do that. Other helpful links you can look at when you have time. This Staying Legal Guide covers a lot of what we talked about today. It's a publication you can print out for free on our website, and you can share with your whole board and encourage them to read that to get a really high-level overview of things you need to know. The Nonprofit Risk Management Center is another nonprofit that has a lot of information about insurance and general risk management for nonprofits. The Foundation Center, and you can go down to the library here in Atlanta. Georgia Secretary of State's office, the IRS, and Department of Labor all have really helpful information for you. I'll particularly highlight that stayexempt.org is a very user-friendly IRS website that helps 501c3s. All right, now I am ready for questions. Lola?
Okay. There is one, and this question relates to raffles and gambling. Do you have to get a license from the sheriff for each county you operate a fundraiser in?
Now, I think the law on raffles, oh, I'm sorry. The question is, when it comes to raffle licenses, do you have to get a raffle license for each county in which you do a fundraiser? I would have to go back and check this, but I think the law is that you get a raffle license in the county in which you are located, and that raffle license is good for all raffles that you conduct. All right, that's the only question we got. I threw a lot at you today, but I hope that was helpful. Thank you.